Hello, everyone. Thanks for joining us today. My name is Joe Bask. I'm joined by my colleague, Mehul Gandhi. Thank you for attending our recap of part one, estate planning. Don't be an estate planning ostrich. So just a quick disclaimer before we get into it. This presentation was created by Mehul, and the opinions expressed here are either Mehul's or mine, and they do not reflect upon HollisWealth or Industrial Alliance Securities. So we're going to review the top 10 estate planning mistakes to avoid. Before we get into that, just very quickly, what is an estate? An estate's just a term that describes everything you own and everything you owe just before you pass away. So really an estate plan should be a set of instructions and wishes about what you want to happen to your assets when you do pass away. So here is our list of the top 10 estate planning mistakes. We're just going to jump right into it. So number one, not having a will. So if an individual passes away without a will, that's known as dying intestate. It can cause problems for your family, and basically the province in which you reside is going to decide on how to distribute those assets. We would encourage you against using a will kit. We believe in professional advice and think you should be working with an estate planning team. Also really important, if you have minor children, or perhaps your children have minor children, you need a will in order to name a guardian. Number two, thinking that your will is a complete estate plan. So we think a complete estate plan obviously includes a will, but should also have a power of attorney, a medical power of attorney, or what is known as a representation agreement, as well as some other documents that are listed here. And it's really important to understand who's going to get what, when they're going to get it, how they're going to get it. Also especially important if you have a blended family, just to avoid any potential problems or infighting, make sure you have an estate plan in place. Number three, the will hasn't been reviewed in years. So it's generally recommended that you review your will every 3 to 5 years. Why is that important? Well, there could have been some life-changing events, birth, death, divorce. Also, there was something called the Wills, Estates and Succession Act that came into effect in 2014. So there's always things that are changing, and you just want to make sure that your document is staying up to date. Number four, putting too much emphasis on probate avoidance. So probate is the process of the courts validating your will, and there's a small fee for that. It's 1.4% of any assets over $50,000. And so oftentimes we'll see people try to avoid that fee. You just really want to be careful about that, because if you're not getting professional advice, you could actually end up creating more problems or a bigger tax liability than the amount you're saving. And a very common example of that are older or elderly parents putting their adult child on title of their home. And why that can be a problem is if your adult child already owns their own property, now that portion of your home that they own is now considered an investment property. And so you could be making that portion of the home actually taxable. And we all know that our primary residence is tax-free. And so obviously we don't want to be doing that. So again, we're not saying that it can't be done, but if you're looking to do that, you want to make sure that you're getting professional advice. Number five, not choosing the appropriate executor and power of attorney. So obviously this is a very big responsibility. You want to make sure that the individual you're choosing is proficient in these matters and is also willing to take on the responsibility. So we've listed a couple of those things that you want to be considering. And I would say probably one of the bigger ones is if your estate is very complicated, you may want to consider having a third party, such as a trust company, listed as your power of attorney or your executor, just because they're very proficient in dealing with these matters. Also, just be careful about US citizens. You could be unintentionally inviting the CRA into your finances. Okay, I'm going to pass it off to Mehul. Mehul, take it away.
Thanks, Joe. So number six, unintentionally leaving an unequal estate. So here's an example that we have for you. We have Sophie and Scott who would like to divide their estate equally amongst both their children. They have $700,000 in RIPs and a primary residence also worth $700,000. It's fully paid off. So in their wills, they leave one asset to each child, but it does not end out the way that they intended. So the son gets the RIFs left to him, and the daughter gets the primary residence of $700,000. Now, the RIFs actually bypass the estate and go straight to the son. However, there's a tax liability on the RIF, whereas the primary residence does not have any kind of tax liability. So who's going to pay that tax liability? Whose sort of portion does that come out from? This will likely cause some type of conflict or at least concern between the siblings, and it's definitely not what the parents intended. So with a little bit of pre-planning, this definitely could have been avoided. Number 7, out of province assets. So we do know that a lot of our clients, especially in Qualicum Beach, have condos down south, whether it be in Palm Springs or Arizona, or they might be from back east originally and have property still back east. And we want to make sure that any estate planning that you do engage in covers all of your property in all the different jurisdictions. So if you have a will prepared in BC, it might not necessarily address your property in other jurisdictions, so definitely be aware of extra provincial property. Number 8, not having a big enough estate. And when we go through the estate planning process, with younger families, we're covering off the risk or talking about estate planning in the event that something happens unforeseen in the immediate future. So in that case, there might be existing debts, there might be dependents that are still that still need to be supported financially after that individual passes away. And then when and even post-secondary education, but when we're planning for long-term estate planning, especially with older individuals, they might just have desires to leave a particular sum of money to charity, to grandkids and things like that. The main thing here is that is the estate you're leaving behind, is it big enough to cover your needs, right? Whether they're immediate or long-term. And one way, if you do have a deficiency or if your estate is not quite big enough to meet your needs, is to use life insurance to top that up. And we will talk about that a little bit later. Number 9, not thinking about the timing of your estate distributions. This one is something that's often not thought about, but here we have a situation where you're leaving your estate to either a young child, a minor, or an individual who might just not be financially mature or have the wherewithal to be able to handle a large sum of money or assets in a responsible way. So the individual leaving that money behind might want to use a trust to stagger the release dates and have a little bit of control on how that individual, that beneficiary is able to use that money. They can do that by taking some of those assets and turning it into an annuity to create a regular income stream instead of a lump sum payout to that beneficiary. And if they're using life insurance to enhance their estate or to leave to this individual, they can make the beneficiary of that insurance policy a trust, and then again use these staggered release dates to control how that money is doled out to that beneficiary. And number 10, finally, something that we find is very practical and often overlooked in the estate planning process is an estate directory. So if you can imagine, you have a spouse here where one individual in the relationship is sort of the person that's in charge of the financial aspects of that household or of that relationship. They're the ones that know and are familiar with the online banking passwords and login information. They know where all the insurance policies are. They pay all the bills. They're the ones that meet with the accountant and make sure the taxes are done. And if that individual was to pass away first, then the surviving spouse might, be very confused or a little bit intimidated as to what to do next. And that can really be detrimental to the long-term financial health of that individual. So what we recommend is creating this estate directory that has all this important information listed down so that no matter who passes away first, the surviving spouse knows exactly what to do, who to contact, where to go, and doesn't have to deal with those type of challenges. So there's your top 10 list. We've done it all for you nice and neat. Hopefully you got some value there. And on behalf of Joe and myself, we will see you on the next video.